HUD just made its biggest change to emotional support animal rules in over 20 years. If you own a rental in San Antonio or you rent with an ESA, this one hits you directly. Here is what actually changed and what to do about it. Policy is going to keep changing. The owners who stay current and keep records stay out of court. The ones who guess end up paying for it. If you want a team that tracks changes like this so you do not have to, that is what we do. At Hendricks, every animal request runs through PetScreening. We check the documentation and keep a clear record of every decision so it holds up later. We do not approve a request without proper paperwork. And when we deny one, there is a documented reason behind it. The point is to follow the law as it actually reads, not how anyone wishes it read. And what about pet fees? A court case called Henderson versus 5 properties found that a landlord does not automatically have to waive a pet fee, even for a documented ESA. HUD pointed to that case on purpose. So a landlord who charges a fee for an untrained ESA now faces far less federal risk. Whether the fee is appropriate still comes down to your facts, so this is not a green light to do whatever you want. If you rent with an ESA, your situation changed too. Filing with HUD will not help anymore if your animal is untrained, because those cases get closed. But the law still requires your landlord to consider a reasonable accommodation. You can still take it to court within 2 years, and Texas law protects you on its own. If you live in HUD-assisted housing, Section 504 may give you stronger footing. So what does this mean if you own property here? The risk math around ESA requests changed. Before, denying a request or charging a pet fee could bring a HUD complaint down on you. That threat is much smaller now. But do not get comfortable. The Fair Housing Act itself did not change. Congress did nothing. Only HUD's enforcement posture shifted. Texas has its own fair housing law, run by the Texas Workforce Commission, and it still applies. A tenant can still sue you in court for 2 years after the fact. So keep documenting every request and talk to a property management attorney before you touch any policy. So why the change? A whole industry grew up selling ESA letters online after a quick form and a fee with no real evaluation. HUD said those fake letters pulled its staff away from people who actually needed help. More than 1 in 5 of its fair housing complaints involved untrained ESAs. HUD wants those resources going to trained assistance animals, especially for veterans. On May 22, 2026, HUD signed an enforcement memo that took effect the same day. It threw out the old ESA guidance from 2013 and 2020 and put one standard in its place. Going forward, HUD will only act on a fair housing complaint when the animal is individually trained to do a task tied to a person's disability. That is the same bar the ADA uses for service animals. So in plain terms, if the animal is not trained to do specific work, HUD will not take the complaint.